start, knowing that I have such experienced attorneys who have all clerked here. I'm in good hands this morning. When I asked my question, Mr. Caldevilla, I know you're muted, but I'm going to let you speak anyway. I see that there's an appeal and a cross appeal. Have you all decided amongst yourself how you would like me as center chair to portion the time? Is it 15, 15, 5, 5? Or did you want to do it the traditional way? So I'm going to ask you before I try to use mechanical skills and a time clock.
So Judge, I apologize, but I have not reached out to opposing counsel, but because we have a cross appeal, I do intend to have rebuttal on my cross appeal if the court will allow that. And I would be reserving 5 minutes.
So does 15, 15, 5, 5 sign right then? 15
for me. I'm the appellee, cross appellate, so Ms. Wofford would go first.
Yes.
I'll take 15 after that. If she has rebuttal, she'll
I'm
take
assuming
that.
5 rebuttal for both of you or each of you rather than, so be 15 for appellant, 15 for appellee, 5 for appellant, 5 for appellee. Do I have it right?
I can't speak for her.
No, but pretty soon I may not ask for a vote. I'll just go ahead and decide, by the power invested in me. Does that sound what you all had in mind, or you have a different plan?
That sounds fine by me.
Okay, then I will do that. And I will try to give you the appropriate warnings when you get close to that so that you know whether or not you are consuming your rebuttal time. Attorney Walford, I believe you had the floor first, and you may proceed.
May it please the court. My name is Joy Walford, and I represent the appellant, Geico Indemnity Company. And we've already discussed the reserved time. This is an appeal from an order granting a motion for new trial based on juror misconduct after a jury returned a defense verdict in a dispute between Geico and a glass provider about the amount due for a windshield repair. Trial court granted plaintiff a new trial based on a retired Air Force colonel's failure to disclose that he acted as a consultant for a risk management firm on the juror questionnaire. Plaintiffs also filed a contingent cross appeal of the portion of the post-trial order denying his motion for a directed verdict and new trial on the basis of Geico's failure to present evidence regarding the amount of the invoice being within the limits of liability. I'd like to start with the direct appeal. The facts are pretty simple. Juror Niederer's response to the jury questionnaire is what's at issue. The questionnaire asked your occupation and employer. Answer, retired military. Questionnaire asked if you are not now employed, give your last occupation and employer. Answer, Air Force colonel. Juror Niederer was selected as a juror and served as the foreperson. After the defense verdict, then Shazam filed his motion to set aside the verdict.
Ms. Wofford, I don't mean to interrupt you, but we've all read the briefs and we kind of know the factual scenario. So I kind of wanted to get into the meat of the issue. So the first question in the analysis about the information that was withheld, was it material? Was it material? I mean, he wasn't employed. He was a consultant or a senior expert, presumptively worked on an ad hoc basis based on some sort of hourly rate. I mean, he said my last job was as an Air Force colonel and I'm retired. That's true, really. I mean, he's basically, I don't know what a consultant's not an employee. It's an independent contractor at best. But the question is the position of this consultant, senior advisor. Is it material? Does it matter?
No, Your Honor. That's why the trial court abused its discretion in granting the new trial here. That's the main reason. Okay. The test for materiality is whether the non-disclosure is so substantial that if the facts were known, the defense likely would have exercised a peremptory challenge to remove the juror from the jury. The inquiry is case specific, depending on the link between the factual circumstances that weren't disclosed and the pending litigation. So in Roberts, for example, the Supreme Court said this type of link is something that would cause the juror to be biased. And there were several examples there, like information that could cause a juror to sympathize with a party, like if the juror had been a defendant in several prior lawsuits or a defendant in a lawsuit very recently, or information that established a bias against a particular party. like if the juror was insured by the defendant or had adverse experience with the defendant or was related to a party or represented by an attorney involved, or information that might establish a bias against the type of lawsuit at issue or lawsuits in general. Here, the reasons Shazam provided that the omission was material don't establish any type of potential bias based on the facts of this case. The first.
So let's go to the next, let's go to the next issue, because I think you've kind of covered that pretty well. Did the juror conceal this information?
No, Your Honor, the juror didn't conceal the information.
Didn't
In
come
order-
forward with it, right? He didn't
Correct.
come forward with it though. So what's the difference between failing to come forward and concealing?
Well, the difference is the nature of the question, and if it is addressed in voir dire. So to show concealment, the plaintiff has to show that the question was straightforward and not reasonably susceptible to misinterpretation. And the juror questionnaire asking occupation and employer, at first glance, it seems like it's straightforward. But as it relates to consulting, the term employment is not straightforward because it's a non-traditional type of arrangement that's not clearly defined. The juror's exact.
But you're still serving a master as a consultant. You have someone who's paying you, someone who's directing you, someone who's hired you. I mean, a normal conversation, something like this would come out. I'm retired military, but I do this now. And that didn't come out on the questionnaire. It didn't come out in voir dire at all. You know, I mean, the difference between concealment and not being forthcoming. I mean, I don't know that there's much difference. It would seem to me this is something that should have been disclosed and just in casual conversation and voir dire.
Well, in this particular case, it was so briefly touched on that there's really no opportunity for the juror to explain or understand that the plaintiff was looking for information other than the fact that he was retired. We don't even know the exact nature of his relationship with Strafe Consulting. The evidence presented in support of the motion for new trial is very scant. We've got a copy of a printout of the juror's LinkedIn profile where he lists himself as a consultant for Strafe Management. And we've got.
So counsel was not diligent in digging up this information? Point three?
Yes, Your Honor, point three. And I wanted to emphasize also that the plaintiff has the burden of proving not just one of these issues, but all three of these issues in order to establish entitlement to a new trial. So, for example, if the evidence isn't material, then it's an abuse of discretion to grant the new trial. And I understand that the employer-employee designation seems simple, but I think it's analogous to the word lawsuit, which the third district addressed in the Public Health Trust versus Medalist case, which is cited in the brief in 2006. And the court held there was no concealment for failing to disclose a divorce or creditor's collection action when asked if they had been involved in a lawsuit. Again, lawsuit seems like a pretty straightforward word, at least to you and me. But the court felt that it wasn't a concealment for failing to disclose it, just like here. If juror Niederer was like an intermittently consulting, providing some type of expert services, working as an independent contractor, it would be reasonable for him to think that he no longer had an occupation per se, or an employer in the traditional sense. I mean, we don't even know how often he acted. Did he report regularly? What kinds of services? We don't know that he actually provided expert testimony. The only question about employment asked of the juror and voir dire is, and obviously you were in the Air Force, Colonel, what was your primary focus? And the Colonel answered that he started out flying aircraft, retired after 24 years, led an organization of a lot of people, and then reopened airfields. There were no questions about how he spends his retirement. And as you mentioned before, Judge Morris, the information that he provided was all true. This was a retired Air Force colonel, and he just wasn't asked any additional questions.
So Ms. Wofford, what's the standard of review in on this motion for new trial and on this issue?
The standard of review is abuse of discretion. However.
So we would have to find that no reasonable judge would have ruled the way this judge did.
Yes, Your Honor, absolutely. And that is because you've got to reapply or look at his application of the De La Rosa test, which, by the way, the judge didn't even apply in the order granting new trial. Instead, the judge found that the plaintiff relied on the information as truthful and that the plaintiff was prejudiced and deprived of a fair trial, but that's not the standard. As a matter of fact, the court in Roberts versus Tejada, the Supreme Court, 814 SO2D 334, held that prejudice is not a part of the De La Rosa test. So, I mean, the court, not only did the court refuse to apply the standard because the standard had been argued to the court, or maybe misunderstood the standard, but the court then, when you look at the application of the elements, no reasonable person, no reasonable court would find that this information was material.
Let me ask you a question on the standard review and Tejada. Tejada speaks of, as you pointed out, prejudice.
Mhm.
As we look at this case, assume hypothetically that the correct legal result would have been to direct a verdict before it went to a jury because the plaintiff had failed to prove its case. Would the plaintiff still be entitled to a new trial if they had failed in any of their elements? And if you want to tell me it's not preserved, you're quite right, it's not. But as I was looking at that, I had this thought cross my mind. We're going to bring the taxpayers at charge to bring in a new trial. What in a situation, if the plaintiff had failed to prove the case, we wouldn't be getting to this one because the trial judge either erroneously or correctly granted a DV. So is there a prejudicial component? And I just wondered. And if you don't want to discuss it, feel free.
Well, I mean, certainly when you get to the point of a jury, the jury verdict and the jury's participation is should not be disturbed unless absolutely necessary.
That's why that's what I'm saying. Prejudice may be when a jury deliberates that you don't have to show prejudice. But what if as a matter of law, it wasn't going to go to the jury anyway?
I'm not sure I'm following that.
If you were going to get a directed verdict.
Yeah.
And the trial court got it wrong and let it go to the jury and it comes back and we were to conclude on appeal that a directed verdict was appropriate, would we have to do any standard of review of abuse of discretion or prejudice if the case wouldn't have gone to the panel anyway? There would have been no harm of non-disclosure.
No, Your Honor.
Which brings us to the next very important issue. Is who bore the burden of proof of proving that the billed amount did not exceed the prevailing competitive price? I mean, it would seem to me that Shazam brought this suit. They basically said, we did the work, we rendered a bill, Geico didn't pay. It would seem to me that's the end of the story. And it would seem to me that Geico would say, well, we paid all that it was worth because they billed an amount that exceeded the prevailing competitive price. And this is what the prevailing competitive price is. And I think you take a different view of that.
Yes, Your Honor. I mean, this started out as the affirmative defense raised by Geico was that the price it paid was consistent with the limit of liability provision in the policy. And
the court struck that affirmative defense, right?
Yes.
So where did that leave us?
Well, that still leaves the plaintiff with the burden to prove a prima facie case of a breach of contract. And here the question is, they're alleging that Geico materially breached by failing to pay under the terms of the policy. By failing to pay, it must be the prevailing competitive price and the limit of liability. When you're looking at what Geico's obligations were under the policy for payment purposes, its obligation was to pay the prevailing competitive price. If you want to draw a distinction between the two, the affirmative defense and the prima facie case, the affirmative defense goes to whether the amount actually paid by Geico was within the prevailing competitive price, but the prima facie case goes to whether the amount invoiced by the plaintiff was within the limit of liability.
So
let
I
me
don't
go from this
understand.
on Judge.
Go
I have a
ahead.
similar question to Judge Morris. Your client, Mr. Caldavia's client filed a cause of action for a breach of contract. One of the issues is there's a contract, a material breach, and damages. Damages is an element of a cause of action. So my point is, inquiry is, you can call it as the defendant did Geico, that it's an affirmative defense, but it's not as a matter of law an affirmative defense because it doesn't admit anything. It deals with an element of the cause of action, and an element of the cause of action is not an affirmative defense. So the trial court was correct to strike it, which in my view then leaves the plaintiff with the duty to prove their case under an assignment of contract and to provide what the value was per the contract, whatever the competitive price is. And if that contract is still standing and they don't prove it, you get a directed verdict. That's my concern. And for the proposition that a principle, the essential element of a cause of action is not an affirmative defense, I would direct you to Judge Gross's opinion for the 4th DCA in RAUCH, R-A-U-C-H.
Yes, I mean, I agree that there's definitely, this is an oddity as far as affirmative defenses go. In a
It's not an
perfect,
affirmative defense, is it? It's an element of the plaintiff's cause of action. It doesn't admit and I escape liability because of latches or fraud or estoppel. It's something the plaintiff has to prove. I have sustained damages under the contract. Isn't that what the assignment gave the plaintiff?
yes, Your Honor,
I'm
that's,
wondering how this affirmative defense that Geico put in is legally an affirmative defense. If I say I'm chief judge and I'm not chief judge, it doesn't make it so. So you can call it what you want, but as a matter of law, I'm concerned that it's not an affirmative defense. And if it's not an affirmative defense, that's kind of why I was asking the question about, should there have been a direct verdict if the plaintiff didn't prove damages under the contract? And if so, there's no harm to your client because we wouldn't go there and there was no reason to have a new trial. But none of these have been preserved. Nobody has raised the thing. But, you know, I can't help myself sometimes when I'm like that rabbit on the thing or the squirrel. I keep chasing, I never catch them. But that was part of my thought process going to do this. If it's not an affirmative defense and it's not stricken and the plaintiff has to prove their case and they prove that I got so much money and that money is not the competitive price, then they fail their burden of proof.
the plaintiff failed their burden of proof because they had to prove that Geico didn't pay under the terms of the policy. How it's separated out is they're arguing.
I'm
that
sorry,
that-
I'm taking you past 15. Since I have, you can answer this one and I'll give Mr. Caldevilla the extra time.
Okay, absolutely. What they're arguing is that, I need a moment.
You want to wait for rebuttal?
Yes, thank you. Let
Fine.
me get my thoughts together.
Okay. All right, let me stop. Mr. Caldevilla, you will have 16, not 15. So let me stop the clock so you don't get charged with time. And obviously you've heard all my concerns and I note none of them are preserved, but you know, much like you lawyers go through your case, so do some of us trying to figure out which channel I'm supposed to go through. And I had a problem with the affirmative defense, whether or not it was in fact an affirmative defense, but nobody challenged it. So it's still there. But I'll let you go ahead and make your argument and rebuttal now. You've heard all the questions, I think. So the floor is yours, counsel.
May it please the court. Good morning, Your Honors. I am Dave Caldevilla. Along with the Lagori and Lagori firm, I represent Shazam Autoglass in this appeal and cross appeal. I will be reserving 5 minutes. Geico's arguments about the jury foreman's answers to the questionnaire are misplaced and incorrect, but this court does not need to reach Geico's arguments about the juror because the jury never should have been permitted to decide this case in the first place. As explained in our cross appeal, after Geico lost its affirmative defenses by summary judgment, stipulated to the dispositive material facts of Shazam's breach of contract claim, and then rested its case without presenting any evidence to the jury, Shazam was entitled to a directed verdict by summary disposition under Rule 7.135. The stipulated and undisputed dispositive facts demonstrated as a matter of law that this damaged windshield was a covered loss and Geico did not pay for the amount of the loss. That gets us to the damages question, Judge Casanueva, that you're concerned about and whether there's an affirmative defense. And I will discuss that in detail. Right now, I just want to get through an overview, but I will answer your question. Geico had no viable affirmative defenses to demonstrate that the $628 amount of loss exceeded the prevailing competitive price, or that the amount of Geico's $310 payment was the prevailing competitive price. So if this court agrees that there were no disputed material facts for the jury to decide, Your Honor should rule in Shazam's favor on cross appeal. If so, Geico's arguments on direct appeal about the jury will be rendered moot. And I think we're right on the juror issue also, and I'll get to that. But I would really like to talk about the cross appeal first, because and it is not a contingent cross appeal as counsel stated. This is a plenary cross appeal that stands as an appeal on its own merits, regardless of Geico's direct appeal. Florida law, Judge Casanova, Florida law applies a burden shifting framework to insurance claims that are allegedly subject to policy exclusions or limitations. The insured has the initial burden merely to prove that the claim is a covered loss. Once that is proven, the burden shifts to the insurance company to prove as an affirmative defense that the claim is prohibited by a policy exclusion, or that the amount of claim is reduced by a policy limitation. That's in the Florida Supreme Court Curran case and about a dozen other cases cited in our brief. This is well settled law. In fact, Your Honor, Judge Casanova, in the Geico versus Superior Matthew Dick case that you just decided not long ago, this court confirmed that this was Geico's burden of proof. It's Geico's burden to prove, just like any insurance company. And you said damages is a component of the breach of contract. Certainly it is. We charged $628, my client did, for a windshield. Geico paid $310, and damages are the difference, $317. These are all disputed, dispositive material facts that Geico stipulated to before we even got to trial.
Let me ask you have a contract that you have taken an assignment of, and you have your rights to ride under that contract. And you are alleging, as the plaintiff, who generally has the burden of persuasion, that we have been damaged because we have not been reimbursed the competitive price. And if you don't prove what the competitive price is, how do you show how you've been damaged?
Because that's Geico's burden to prove what the prevailing competitive price is. My burden is to prove what I charge.
You're the plaintiff. You go first.
Right. We did go first.
You don't prove anything, you'll never get to the defendant's affirmative defense because the burden won't shift. If you go first and you say we rest, and you've not proved a scintilla of evidence of how much it costs, and it's not an affirmative defense, but we'll leave that for another story. You have a burden of the contract. How do you impair the contract by saying they have to prove it and the rights that I got under the contract don't go? I read that current case, and in context, I understand it, but I tried to extract that rule here, and I'm not yet comfortable with it. So you get a chance to make me comfortable with it.
Okay, Judge. Well,
you think of all the times that you are the plaintiff and you say, we have rested. And if you haven't proved the elements of your cause of action, this is how much this is, and we're entitled to it, and we only got Y, leaving amount Z. What happens?
Okay, Judge. Well, we put in an invoice for the amount of our charge, which originally was $716, and my client stipulated to reduce that.
Charged. The contract says we have a limit of liability here that we only pay this value. Which is defense. Isn't that the value you're entitled to under the contract?
Judge, that is a defense in every insurance case. I'm sorry to disagree with you, but the law is extremely well settled on this point.
I've got the case from the Supreme Court to prove it. I just want to make sure I understand the concept, right? And I'm not sure that it's been raised to my satisfaction, but I'll go back, I'll recurrent again and see if I can extrapolate that rule here. The customary practice is the plaintiff bears the burden of persuasion of their cause of action. And if you have a contract and yours is an assignment of rights, the assignment of rights says we will limit the liability under our contract to this. So the most you can be entitled to under that contract is this. I'm concerned that this cause is unconscionable because no one can prove this terminology.
Judge,
they created something they can't prove, and now nobody has.
They can easily.
I don't know how the Department of Insurance allowed it to come out, but they did. But that's another story for another time.
So
I
Judge.
got your argument. I'm fully grasping it.
So they could,
We'll go back and play with it again.
so Judge, again, the insurance policy initially agrees to pay for the loss, right? The
Yes, sir.
loss is the amount of the claim. Now,
Correct.
they also have a truncation of that promise, which is the limit of liability provision, which the Florida Supreme Court in Kern, and like I said, a dozen cases that are cited in our brief, including the one you just decided, the Matthew Dick case.
Well,
It is
remember,
their
they
burden.
are
It is-
decided based upon the issues that are raised when we got here.
Yes,
So,
sir. And
no
that's the
one
same in
raised
this
them.
case.
That's why I wanted to raise it
accepted-
here, because I wanted another shot to make sure I understood what was going on, and you have enlightened me. I appreciate it. And I will look at it again,
Judge,
again.
very respectfully.
Yeah, I mean,
Hey,
very
it's
good
our-
point.
it's
I'll
our-
go back and read Curran again and see how expansive the language is, and maybe that I'm unduly narrowing it.
So we have a burden to prove that it's a covered loss and the amount of the loss. And the Florida Supreme Court just recently explained what a loss is in the context of insurance claims. And that's the American Coastal versus San Marco case, which we cite in our reply brief. Loss in the insurance context refers to damage resulting from a covered event. The damage in this case was the charged amount. Then it's up to GEICO to say, well, wait a minute, we've got a special contract provision that says that we don't have to pay the full amount of the loss. We get a
It's a
limitation
setup.
of liability. That's their burden. And that's the same in many different, anytime there's a statutory or contractual cap on the amount of damages, that is always an affirmative defense, including the Gottlieb case, again, Judge, which you decided.
I
That
did.
was a case
Under
involving a
UCC.
contractual cap of liability based on the UCC, and it was the defendant's burden to prove that cap, not the plaintiff's. So this was their burden. They stipulated to the dispositive issues of fact, and it's the dispositive issues. We presented everything there was. GEICO presented nothing.
You've
They
addressed my
rested their case.
concern. You know,
Thank
you've
you,
addressed my
Judge.
concern. I've
I
got
want to
it.
make sure that I've addressed any concerns that Judge Morris and Judge Valenti
Fair
have
enough.
also. And I appreciate that, Judge Casanova. But, you know, the jury was instructed in this case. The parties have agreed to certain facts. You must accept these facts as true. Fact number one, the policy was issued by the defendant and the loss is covered by the policy. Fact number two, plaintiff submitted an invoice to the defendant requesting payment for the replacement of the windshield in the amount of $716. Defendant submitted payment to the plaintiff for the replacement of the windshield in the amount of $310. The jury was also instructed that the jury must disregard any mention by GEICO of the limit of liability. That's because they lost that point on summary judgment. These were jury instructions that GEICO did not object to and has not raised on appeal. Under these circumstances, the jury verdict was contrary to the stipulated dispositive facts and contrary to the law. That verdict should have been vacated, with Shazam being awarded a final summary disposition in its favor. Alternatively, at the very least, Shazam should have been awarded a new trial because the jury's verdict was clearly contrary to the manifest weight of the evidence. In fact, there was no evidence to support the jury's position on this, especially given the stipulation of dispositive fact. So irrespective of GEICO's arguments concerning the jury foreman's false answers on that questionnaire form, Shazam's entitled to a final judgment in its favor, or at the very least, a new trial based on manifest weight of the evidence. So, notwithstanding Shazam's cross appeal, GEICO should also reject GEICO's arguments on direct appeal concerning the jury foreman's false answer on the questionnaire form. GEICO's direct appeal is governed by the abuse of discretion standard, as you noted, Judge Morris. Now, GEICO's only argument is that the trial court supposedly violated this three-part test established in the Della Rosa case. Well, it's mentioned in this court's case many years before, the Skiles versus Ryder and many other cases, but the Florida Supreme Court adopted it in Della Rosa as the law in Florida. And there's three parts to that test. And Judge Morris, you went through the three parts with counsel, and I'd like to go through those as well. The first one is whether the information is relevant and material to jury service, not to the case, but to jury service. Counsel says, oh, it's irrelevant. Well, first of all, how can it be not material? I've cited in our brief treatises and at least 4 appellate decisions, all saying that a juror's occupation is very important in the voir dire process. Now, imagine this, Judge Morris. Let's say we didn't have this questionnaire, and I asked juror number 7, what is your occupation? Geico says, oh, object. That's totally immaterial. Could that objection possibly be sustained? Of course not. Occupation is critical to understanding the juror's perspective, a potential juror's perspective on how they're going to judge this case. And it's something that everybody wants to know. Everybody wants to know, is this person a claims adjuster for an insurance company? Is he a surgeon? Is he a lawyer? Is this witness a teacher? We need to know.
In this case, Mr. Caldevilla, he was merely a consultant or a senior advisor. So what if he was in the Boy Scouts, or what if he was in Rotary, or a member of the Tampa Yacht Club? Are those things also relevant? I mean, this isn't necessarily an occupation for him. It's an endeavor for him, much as those other things are.
Okay, Judge, it is his occupation. His occupation is a consultant and an expert witness. Let's be clear about that. That's what his occupation is. The question asks, what's your occupation and your employer? He could have said senior consultant, senior expert, self-employed, or this company that likes to the Strathkey Risk Management Company, that is a company that offers expert perspectives on risks faced by industries, manages the creation and placement of alternative narratives, whatever that means. It doesn't sound very friendly. And they provide corporations and their legal counsel with litigation support and expert witness services. Let's look at the Della Rosa case, Judge Morris. In Della Rosa, the juror had prior litigation history, okay? This juror, in our case, had prior litigation history probably because he's an expert witness. He's a consultant for litigation. So that was...
We have to assume he got hired at least once.
Well, he says that's what he's doing. So, and that's not even questioned in this case. Geico hasn't challenged the veracity of the information that Shazam was able to find.
Do you mind touching on the due diligence issue of this case?
Yes, I would love to touch on that as well. Thank you, Judge Valenti. So it was concealed because he didn't provide the information requested. And getting to the third point, the due diligence. Now, this information is on a questionnaire that's provided by the Florida Supreme Court, as these are the questions that we want all jurors in the state of Florida to answer before voir dire even begins, as part of to simplify the voir dire process. Now, as a trial lawyer, am I expected to go through each juror, and ask them the questions posed on this questionnaire and say, well, is that really true? Is that really your occupation? Is that really who your employer is? Of course not. We are allowed to rely on the jury's answers as being truthful. And that's in the case law. It's cited over and over again. And it doesn't matter if the juror intentionally concealed this information. The word's concealment, but the case law explains that just really means failed to provide. He failed to provide the information of what his occupation is. His occupation is working as a consultant and an expert for a company that provides litigation services and alternative narratives in litigation. That's something that we would have wanted to know. Now, do we have to follow up questions for every question? No, we don't have to do that according to the case law, Judge Valenti. And I'm sorry.
But after you get a verdict, are you entitled to basically do your due diligence after the fact?
Yes.
I mean, that's kind of like getting a get out of jail free card, isn't it?
Well, can we should we stop the case and say, well, we need to go back and do
Well, no,
research
you
on this
said you got
20
the questionnaire ahead of time. You got
well,
the
we get
questionnaire
minutes
before
ahead
you
of
even.
time. We get it
You're
right.
right at 16, but that's okay.
All right.
He had and spent a lot of time dealing with me. I'll give him more time.
Thank you, Judge. I'll wrap up, but Judge Valenti, these questionnaires are handed to counsel right before the jury walks in. So, you know, are we supposed to go and do background checks on every juror, or can we just rely on the veracity when they take the oath and say that they're going to answer questions correctly, and they're given these questionnaires to answer? Are we to expect that they're lying, or are we to be able to rely on the information as being truthful and simplify the process? We've got not even a $300 small claims case here. Are we to go out and hire investigators to do background checks on every juror? No.
You're saying due diligence is satisfied by the fact that you relied on the questionnaire.
Well, the questionnaire asked the question and it was answered, and yeah, we're allowed to answer. We're allowed to rely on that and don't have to go through investigations and background checks, or even follow up on questions that are already plainly stated, squarely stated, and squarely answered. The question is squarely stated. What's your occupation? That's not a hard question. It's not confusing. Your occupation is a consultant and an expert. You're telling the world that on your LinkedIn site, but you don't put it on your juror questionnaire answer form. So based on that and the arguments in our brief, you know, we request that if you reverse, it should be to give us a final judgment in our favor, or at the very least, a new trial based on the manifest weight of the evidence, or on this juror concealment issue, or both. Thank you.
Thank you, counsel. Thank you for bearing with me. I appreciate it. And while you were doing that, I took another look at Corinne. I'm reading it again. Attorney Wolford, we're going into your rebuttal. I'm going to do my best again to keep the times even. You had 16, Appellee had 18, so you get an extra 2. You go with your 5, right? So you're up to the magic number of 7, and hopefully none of these are the Powerball numbers for this weekend. And you are muted. You're muted.
Mute.
You're muted.
Computer's
It's
on.
usually me. That's why I keep repeating myself, because people tell me I'm muted. So thank you.
I'd like to start with the jury service while it's fresh, if that's okay with you. I just, you know, the statement that the connection between the omitted information and the underlying case is not important is not borne out in the law. It is not the connection to jury service in general that's important. It's the connection to the underlying case. That's the Roberts case. And they specifically talked about, otherwise you're in a per se error kind of thing. Is there misrepresentation? Yes, then it's reversal. We're all the way to a jury verdict here, and the Supreme Court, when it fashioned this 3-part test, did not want to allow for a per se error based on a non-disclosure. Instead, you had to look at materiality as it pertains to the facts of this case. Also, I just want to clarify that Juror Nieder does not hold himself out as an expert witness. He holds himself as an expert consultant, a risk management consultant, but there's nothing about litigation on his profile or on Strafe's website about him doing expert witness testimony, nothing at all. And then the argument that the due diligence requirement is satisfied just with the juror questionnaire, again, makes no reason for the De La Rosa test in the first place. There's a diligence requirement for a reason, and that goes in most of these cases that you'll see are these litigation experience cases. So do you have litigation experience on the juror questionnaire? Yes, no. Then counsel has a duty to clarify what it is they're looking for, because there are so many different types of litigation. Here, if counsel wanted to get to arrangements beyond the traditional employer, I'm going to work on a daily basis, it had the opportunity to ask that, and it didn't. I'd like to take it back now to, to the cross appeal, if I may. And I want to start with Judge Casanueva's question, our concern about whether this is an affirmative defense. And I think the best answer to that is it doesn't matter. if we start with where this case is procedurally, right now, the argument on cross appeal is that the court erred in denying a motion for directed verdict or summary disposition based on the failure of the defendant to present evidence. That's turning the burden of proof on its head. As stated from the beginning, it is the plaintiff that bears the burden of proof. There is no getting out of that burden of proof. If there was an affirmative defense, and there are generally affirmative defenses where you can admit to the underlying elements, then that relieves the plaintiff of their burden of proof. But this isn't one of those cases. This isn't a general coverage action. And so the test that counsel is suggesting applies about whether, it's a covered loss and whether it was complied with. That's not at issue. This is a dispute over the amount paid.
What would you have them do in this case to satisfy the burden of proof? What more should they have done to satisfy the burden of proof?
They had to prove the amount of the loss. I mean, you want to call it damages or you want to call it breach?
And what amount did they put in evidence?
They put in the amount that they invoiced, Your Honor, but that's not what the insurance policy says. This is a contract between the two parties where they agreed to pay that the prevailing competitive price would be paid. They can't go in and ask for more than the prevailing competitive price and then say it's a breach because somehow the burden is on the defendant to prove the prevailing competitive price. It's an element of the material. What if they had asked for an invoice of $10,000? What if it was $1,000? Would it really be a breach of contract not to pay that invoice? There's got to be a burden here on the plaintiff to prove their case based on the terms of the policy. And here, that limit of liability provision is a term of the policy, and it speaks directly to what is a breach and what is not a breach. Any more? Is there anything else on that? If not, I'm going to go with the request for relief here. Going back to the beginning, the court erred in granting the new trial on the basis of juror misconduct. So GEICO requests that the court reverse the order granting new trial and remand with directions to reinstate the jury verdict. The cross appeal should bear no moment because, again, you've got to look at whether the plaintiff is entitled.
Counsel, you have frozen.
Excuse me?
Okay, you're back. You had frozen for a second.
Oh.
My picture went still, no sound.
Good, I'm back. Okay. So their burden was to prove not that they're a prima facie case, but whether they're entitled to a direct.
Happened again. You are still frozen.
How about now?
Now you're fine. Every time you ask me, how about now, you're perfect.
I better quit while the quitting's good, I think. We request reversal and remand and no relief, of course, on the cross appeal. Thank you.
Thank you. Mr. Caldevilla.
Thank you.
I forgot to ask you, I do hope you're feeling better because the last time you were scheduled, you were ill. So on behalf of the panel, we hope you are improved. You must think you should put up with me all morning.
Yeah, I caught pneumonia, believe it or not. I hope that's not part of my rebuttal time, though.
No, my hands have not touched the clock.
All right.
You're ready to go.
Court, I am. And so with respect to my cross appeals, which I'm limited to on rebuttal, I'm going to respect that. And counsel has focused on the affirmative defense and whose burden it is. So that's what I'll be using my time to rebut. Now, GEICO in this case, in the record and in their brief, has acknowledged that proving the prevailing competitive price is their burden. And
They stipulated to that, did they not?
They did. So
that kind of removes that issue, as I mentioned earlier. It's not preserved, and we have a stipulation on top of it.
Right. So let's make that crystal clear. That is their burden. They accepted that burden. They pled it as their burden. It's their burden. But counsel asks, well, what if it was a $10,000 bill? Well, it wasn't a $10,000 bill. It's a $628 bill. But again, GEICO's policy, if you go to the limitation of liability provision, Judge Castanueva, you ask how can they possibly prove it? It's not provable. Of course it's provable. How did Geico decide to pay $310? Because they say that they say we only have to pay the price that a competent and competent and conveniently located shop would agree to charge us. Okay. And what they say after that, Judge Casanova, please look at it. It says, listen, insured, if you want to know the name of a shop that will accept the prevailing competitive price, call us and we will tell you. Well, why can't Geico, in any lawsuit that we've ever seen, in any of these windshield cases, but this court has affirmed 60 of them, about 60 of them. Why can't Geico ever come forth and tell the court or the jury, well, here's the windshield shop that would have accepted $310 to swap out a brand new windshield on a Ford Explorer, $310. It's this shop right down the street, Acme Shop. And guess what? We've got their owner right here on the witness list, and we're about to call him. Dear Mr. Acme Windshield Shop owner, how long have you been in business? Oh, I've been in business 20 years. Oh, so you're competent then. Have you ever changed a windshield on a Ford Explorer? Oh, thousands of them. And would you accept $310 to change out that windshield and put a brand new one on and transport it out there and put all the adhesives and change the clips and make it brand new, shiny for $310? Oh yeah, we do it all the time. You know why they don't ever call somebody like that? Because they can't. Because they want to pay half the price of what the going rate is for a windshield. That's what all these lawsuits are about, Judge Casanova, and it is their burden, not my burden. My burden as the plaintiff is to show, here's my bill, it was $600. Or if I have a roof that I've replaced, the roof was $10,000. It's up to the insurance company to come back and say, well, look, our limit, and it's all well and good that you had a $10,000 bill here, but our policy says we only pay 50% of the going rate. And so here's your check for $5,000 or whatever standard they want to put in their limitation of liability. That's their burden to prove. I mean, how did they come up with $310? They won't tell you. We go through discovery. Look at all the 60 lawsuits that have been appealed and affirmed in this court. Pull them all up, and you'll see that every time the plaintiff says, how in the world did you come up with this number that you paid us, Geico? Oh, that's a trade secret. That's irrelevant. We don't have to tell you that. Of course you have to tell us. How can you pay us an amount and not tell us how you came up with it and contend that you complied with the insurance policy? How can you contend that you complied with the limitation of liability without telling us how? That's their burden.
Caldini, my question was premised on the fact of only this case. I contained myself to the record of this case. And I note that they were not able to sustain the proof of their so-called affirmative defense, which leads to the conclusion that maybe this contract clause is not meant to be a legitimate, arguable method of payment, but rather a discouraging thing, which may render it, as I mentioned, unconscionable, ambiguous, or whatever. But I don't know that I can go through all my cases when I'm only asked to decide this one. So let everybody, that was what prompted my case. They did not prove what they called their affirmative defense. And there are stipulations. So I'm staying there.
That's fine. And
I understand
that's totally
your
fine.
question and the rhetorical nature of it. And that was one of my thoughts why I phrased that based on this case and the stipulation and their judge's order, no evidence.
So what I would just want to make clear is they stipulated not only to the material facts, but to the dispositive facts of my breach of contract claim. My client's breach of contract claim, those are the three elements. It's covered loss. Here's what we charge. Here's what you paid. Falls in your court, Geico. Well, we rest. Well, then you're done. We win. We win because you stipulated to the dispositive material facts. We should have gotten a summary judgment in our favor, a JNOV afterward, under that rule. This is clear.
We're a little past 5, so you need to
I'm wrapping up.
close out.
So we request that you sustain our cross appeal, grant Shazam a final judgment in its favor based on those dispositive facts. At the very least, it was against the manifest weight of the evidence, the jury's verdict was, and should be remanded for a new trial on that basis. and the juror concealment issue as well. We've met the three-prong test on all three prongs. So thank you very much. And I know I went over and I appreciate it. Thank you.
Thank you both. I'm glad to see both of you. It's been a long time since I've seen other members of past members of our court. So it's good to see you. I'm glad to see you both in good health. I was a little concerned, when we got the word on the continuance, Mr. Caldevilla, that you were not well. So I'm glad to see that you're in good shape. And we will now move on to our third